Recording in progress.
Good evening, everyone. It being 7:01 and a quorum present, I'm going to call this meeting of the Planning Board for February 11th, 2026 to order. Mr. Grandy will not be joining us this evening. Pursuant to Chapter 2 of the Acts of 2025, an act extending certain COVID-19 measures adopted during the state of emergency and signed into law on March 28, 2025, this meeting will be conducted via remote and in-person participation. Members of the public who wish to participate in the meeting may do so either in person or via remote by the Zoom link. The information to participate remotely is available on the town website. Beginning tonight with our administrative notes, we have no minutes. I'm going to go straight to covenants, plans, and releases. We have Form A Plan A4910, 44 Russell Street, Edward P. Lewis Jr., map 019, lot 010, to divide and create 2 lots. Any questions from the board? Seeing none, I'll entertain a motion.
Motion to recommend approval.
I have a motion to recommend. Do I have a second?
Second.
I have a motion and a second. Any further discussion? Seeing none, I'll call for a show of hands. Mr. Smith, you can vote. It is unanimous. So that is 4 members unanimous and the alternate also voting. Next, we have announcements for this evening. I just want to give the board a quick update regarding the proposed land bank legislation. The legislation remains in the Joint Housing Committee at the State House. The time for reporting has been extended until March 18th of this year. So our legislative delegation is certainly amenable to hearing more from residents in support.
Okay, turn it down.
There we go. More from residents regarding support for the legislation. Moving next, we're going to take this out of order. I have ZBA 4203, 7 Bay Colony Drive, LeSueur Family Trust. Special permit required per section 203-1C for an accessory building location to waive the required side setback for a post facto building. Do we have somebody here for that? Would you coming up to the podium and introduce yourself, please?
Sure. My name is Greg Karsner. This is my wife, Jesse. We're the homeowners at 7 Bay Colony Drive. I think just in order to kind of eliminate any confusion and just keep things consistent, I was just going to kind of read the permit, and then, of course, we can answer any questions afterwards, if that's okay with you.
That's fine.
Okay. So recently moving into our home last year, we did install an in-ground pool last summer and planned a pool cabana to complete the outdoor space. So during the planning process, we believed that all 4 posts of the cabana, which are currently installed with footings, would be located more than the required 10 feet from the property line. So this belief was based on the current existing lawn and garden layout. There's a physical barrier, a stone wall, and we were, I think, 13 feet away from that. So that's kind of like what we went off of, is that physical barrier. Historically, everything on our side of that stone wall we've maintained, and everything on the other side of the other side of the stone wall has been maintained by the neighbor. So that's kind of the thought process behind that. So once the official property boundary markers were staked after the installation of the pool and the 4 footings for the cabana and the fence surrounding that, we discovered that our assumption was wrong. So we made a mistake. And that our property does not extend as far into that wooded area. It's, lawn, a wooded area, and then our neighbor's home. And that 3 of the 4 boundary posts currently meet the required 10-foot setback. However, due to the angled orientation of the structure, which was designed, in fact, because we have a 2.5-year-old and a 6-month-old, so the way that the backyard kind of presents itself, we angled the cabana so that we could just see our young children going forward. So one of the posts is 3 feet 9 inches away from the property line. So I think that's kind of the bottom line up front, is that one of the posts is 3 feet 9 inches away from the property line instead of the 10. So we apologize for that. But at the outset of the project, we did not apply for a building or zoning permit because we understood from the experienced reputable shed contractor company, Chapin Sheds, who's done plenty of work here in Plymouth, that they just told us that, like, hey, this is under 200 feet, so you don't need a permit. And so we kind of went off that. We didn't hire a lawyer to double check their work or anything like that. But after construction was paused due to the boundary marker staking, we became aware that the height of the cabana placed it outside of that exemption. So we should have applied for a permit. And since we've owned the home, we have applied for more permits than I can remember. We don't, you know, we're not trying to do anything not above board. So again, I apologize for that. It's just, it's my fault. So once this was realized, we immediately began working with the town to address this issue properly, which, you know, has resulted in why we're here today. So at the time this was identified, the cabana was just about 90% done, and all the work has since been paused since then. So that's why we're requesting this special permit to just kind of waive that required setback for the one post that is only 3 feet 9 inches away from the property line instead of the 10. So if you don't mind, just maintaining the cabana in its current location just preserves a full unobstructed view of the pool from the windows of our home. And this visibility is important because when planning the cabana, you know, we have 2 young children. We just want to be able to see everything from our windows and from our home and from the Ring camera at all times. So this also accommodates the existing concrete footings that were poured as part of the patio and the structural support for the cabana, just avoiding disruption to the finished hardscape. And this just, it really prevents a significant and unanticipated financial burden for relocating this, and as it would require demolition and repair of the existing patio and footings, resulting in thousands of dollars in additional cost and potentially negating a substantial portion of the many thousands of dollars that we've already invested in this. And you know, it also allows us to apply for the required building permit for the structure site and to just complete the project in full compliance with everything the town is asking of us. So the cabana doesn't create any obstructions, visibility issues, or adverse impact to neighboring properties. We'd spoken directly with the abutting neighbor who had expressed no objection to the cabana remaining in its current location. And consistent with section 202.6 of the zoning bylaw, the proposed use is of high standards and will not violate the intent of the zoning bylaw. It's consistent with the purpose and intent of the residential districts where we are, and the safe and harmonious exercise of this special permit will be provided by adequate fencing and plantings to ensure privacy, which both us and our neighbors desire. There's no hazards to pedestrians, vehicles, and there's no nuisance or adverse effects upon the neighborhood which will be created. So that's why we're here tonight, and we appreciate your time and are looking forward to answer any questions or is anything else we can clarify for you.
Great, thank you. So one of the reasons that you're here tonight is because this is an ex post facto. So as a board, we look very seriously at that. Obviously, you know, we're here to enforce the rules on behalf of the residents, so we always get concerned. But I understand that you were the ones who self-reported when you discovered that this was an issue. Is that correct? You were the ones who contacted the town?
No, so when the land was surveyed, we don't know who contacted, I assume the neighbor, because she had asked if she could survey the lawn so she could plant trees, which we had talked about, and that's when we both discovered that it was too close.
Right, you discovered it, but that's when you contacted the town?
No, they came out to
They
us.
contacted
Yeah.
the town?
Correct.
Oh, the
Yeah.
town came out?
Yes.
Correct.
Okay. So one of the things that I'll make a recommendation when you go before the ZBA, following us, is have a letter from your neighbor. That it's all well and good that you say this, and we have no reason to doubt you, but it's a lot easier when there's something in writing to tell us, gee, I'm the neighbor, I don't have a problem with this, because that's probably the biggest factor that weighs in on most of these. But let me turn it over to the board and see if anyone has any questions or comments. Mr. Donaldson.
Actually, this question is for staff. Is this one of these things that we should look at, whether or not this should be coming to us or going straight to the zoning board?
Yes, thank you. So as we've been discussing our policy of advisory reports, we are moving away from having single-family home uses come to this board. However, given that this was a post facto in discussion with the chair, we determined that we would stay the course on this one.
Thank you. And I'm just going to kind of regurgitate what the chair has said in regards to making sure you speak to your neighbors and have them, if they're a letter of good confidence, that's going to go a long way. And I mean, even though you're coming to us, that would have been something that I would have liked to seen, just to make sure, not that, trust but verify type of thing. Not that we, so that's all I have, Mr. Chair. Thank you.
Thank you, Mr. Donaldson. Mr. Mann?
No questions.
Thank you. Mr. Bennett?
Just in case you haven't heard it enough, I'm going to third the suggestion that you get the letter from the neighbor, because that was going to be my first question. Good luck.
Thank you. Mr. Smith?
My questions have been answered, so thank you.
Very good. At this point, I will entertain a motion.
Motion to recommend to ZBA.
I have a motion to recommend approval
Approval, yes.
to the ZBA. Do I have a second?
Second.
Any further discussion? Seeing none, I'll call for a vote. All in favor? It's unanimous of the board and as well the associate member voting in support. Thank you very much. Good luck at the ZBA.
Thank you.
Thank you very much for your expertise.
Next on our agenda, we have the Cedarville Steering Committee appointments. We have one vacancy for a term expiring June of 2027. We have two applicants, Joseph Asatadu and Michael Lasnik. Mr. Lasnik did appear before us before, and we did indicate that we've spoken with him, so he did not need to appear coming back. We understand, just for everyone's memory, Mr. Lasnik was the individual who resides in town part-time during the summer, but said he would attend meetings as they came about. Do we have Mr. Asatadu? He's obviously not in the room. Is he on Zoom? Okay. So at this point, I'll entertain a motion. Or actually, Mr. Mann, please, go ahead.
I think it's a point of order. Looking through the policy, which we haven't adopted yet, I'm not sure it's consistent through the town, but within these policies, there's a suggestion that there's two ways you can qualify to be on one of these appointed committees. One of them is being a town resident, and the other is being a business owner. It does not say a part-time resident. So I'm wondering what the standard policy is. Is that the case, or is this a change in the suggested policy?
It is an interesting question. There is actually no real defined policy in the sense that we typically have said resident, but we don't define what a resident is. And that may be, and that's, I think, something legitimately for this board to decide in, and I'm willing to say on a case-by-case basis. There may be some incidents in which a part-time resident makes sense, and others in which they do not make sense. And when we have discussion point, I'll put my 2 cents in on that, but I'm willing to say first, do we have a motion? And again, I remember Mr. Asatadu was on the board and to my knowledge was regularly attentive, and there were no objections to his activities there.
So, Mr. Chairman, I'm going to make a motion that we appoint Mr. Michael Lasnik to the committee. And do we need to accept the motion before we have discussion? I would like
Yes.
to explain my reasoning.
Yeah, sure, so I have a motion. Do I have a second?
Second.
I have a second. Okay, discussion. Mr. Bennett.
So my reasoning is that, Mr. Eseridu has been on the committee, so he's had an opportunity to serve, which, I welcome and commend him for that. However, we've had now 2 opportunities when he had a chance to be here and present his case to be on the committee, and we haven't seen him. Mr. Lasnik has showed up at the meeting previously. His background is I'm sure, it's different, and I think that an opportunity to someone who has not yet participated in town government be afforded that opportunity. So those are my reasons.
Very good. Mr. Mann, any discussion? Turn your mic on.
It's a tough one for the reasons Mr. Bennett outlines, in that we haven't seen Mr. Acetatu. And at the same time, I'm conflicted in the sense I know the Cedarville Steering Committee has moved forward in terms of their level of engagement and participation in activities, and I would hate to disrupt that momentum by bringing in a new candidate who doesn't live in the town and might not necessarily be available in the way I think you want the steering committee people to be available, which is really in the community, feeling the vibes, so to speak. That's my feeling on it. I seconded the motion. I'm not sure I would vote in favor.
No? Thank you. Mr. Donaldson, any comments? You don't have to.
Yeah, I don't have to. No, I think looking at just the fact that Mr. Azarado has had 2 chances to plead his case, and even though we have a part-time resident, we know that a lot of our part-time residents end up being full-time residents after retirement or so on and so forth. So I'm okay with the nomination.
Mr. Smith?
I'm concerned for both reasons discussed with these 2 candidates. However, not showing up or not making their presence, not letting us know that they weren't going to come here, I think is significant. Having a part-time resident in the position, I think, is something that if we allow would be something that might be a sort of a one-off. So that's where I am at the moment.
Okay, my thoughts on this are first to remind this board that we don't have to appoint anyone that we don't believe is appropriate. This is not a circumstance in which we have 2 candidates and one gets in by default. We have every right to say no to both candidates and ask to re-advertise the position. So that is certainly an option available. With respect to Mr. Lasnik, one of the reasons that we have the requirement that someone either be a business owner or a resident to be on one of these important committees is that they serve not only for themselves, but obviously as representatives of the community. That tends to mean that they are in the community on a regular basis. And especially when we talk about the steering committees, the role of the steering committee is to serve as an ear to the community, which they then report back to us or to the select board when there are issues and challenges that the residents are facing that hopefully one of these boards can address. If Mr. Lasnik is showing up for meetings, that's great, but his ear is not to the ground on a regular basis for at least so far the majority of the year. So while I certainly respect his experience and I appreciate his willingness to serve, for something like a steering committee, as opposed to a different type of advisory committee where there are matters that can be studied and participation in the meetings is the central part. This is something where the steering committees are such that I see them as far more important as listening groups for the residents, not just for being at the meeting, but also hearing from the residents as you're a part of the community and bringing to the attention of the steering committee things that you've heard, and that's how the steering committee is going to advance. So that is my concern when it comes to this and why I think the requirement makes sense in this particular instance. So that's where my sentiments lie. So any further discussion? Okay. I'll call for a vote. All in favor of Mr. Lasnik? All opposed? I have 1 in favor, 3 opposed, as well as the alternate in opposition, so the candidate fails. Is someone going to make a motion for Mr. Asatadu? And again, I'm also of the general sense that if you don't come, it's very difficult to actually address your candidacy. Seeing no motion.
I was going to make the motion that we appoint Mr. Asatadu. I believe, that's my motion.
Okay, so I have a motion to appoint Mr. Asatadu. Do I have a second? Hearing no second, the motion fails.
I have a motion.
Mr. Donaldson.
Motion to repost.
Okay, I don't think we need a motion for that. I think that's the automatic fallback position.
Just want to make sure.
Okay. Having not posted for these two, not approved these two candidates, we will repost. Obviously, the candidates can reapply, but I think they'll understand what our position is. And maybe this is something that I will reach out to the chair. I don't know if the Cedarville Steering Committee actually has a chair. I think that was one of their problems recently. They were waiting, but I will reach out to the person who is currently running the meetings for the Cedarville Steering Committee and let them know where we stand and that they should get the word out for someone who is truly interested in participating. Next on our agenda, policy discussion, and we have the planning board handout and code of conduct. And let me start by giving everybody the genesis of this. So one of the things that this board has been very active in doing for the last several years is trying to be more transparent. And in transparency, one of the best ways we can do that is by letting the residents know in advance what is expected when they appear before this board. And in this instance, that's what the handbook is intended to do. Additionally, it's to provide guidance to those who come before us seeking to be appointed by this board to other bodies as to what is expected of them. The materials that are contained in the handbook are either statutory, and those statutes are identified, or they are the current practices of this body. And we are merely codifying them so that residents understand as they come before, much as we have done, for example, with our submission policy and with our public comment policy, so that residents understand exactly what's to be expected of us, and it shouldn't be making any changes as far as that goes. With respect to the code of conduct is the same thing. It is in essence what we have done in the past, as well as what is required by statute. We have just tried to clarify for everyone so that everyone understands what needs to happen with respect to, A, the behavior of those on the board and those who are appointed, and those who wish to bring a grievance for failure to follow that code. But I will open it up for discussion. Mr. Mand.
Well, this is a big issue. I think we should give it its deserving time. Overall, it's important, I think, we adopt one. I had a brief discussion with Ms. Lynn that the Planning Board has tried on many occasions and not completed this task. So I really hope that we can complete this task. When I went over it very carefully and looked at it for areas where I thought it was maybe not specific enough or too specific or other areas. So I have lots of little things that I could maybe briefly address. What I think are potentially legal red flags and vulnerabilities, for example, Section 2.1 that applies the Code of Conduct to situations that could discredit the reputation or interfere with the functions of the town. And that's not limited to official capacity, in the official capacity. So I think that that's a concern on a First Amendment level, but potentially fraught with long-term issues or whatever. Excuse me if I'm reading this, because it's very detailed here. Section 415, complaints, responses, and the contents of all proceedings shall be considered confidential unless, I'm not sure that's legally enforceable. I'm not sure a board can unilaterally declare records confidential.
I'll just correct you there, Mr. Mann. That's actually the statute. They are by definition confidential unless one of those two things happens. That's actually statute.
Okay. Then there's the elements of discipline of elected members that potentially might be exceeding our authority. I'm hesitant by instinct of those kinds of things. I think the few instances when I've been on the board where we had disciplinary motions that I felt uncomfortable with them. I'm not sure elected officials can be disciplined by their peers.
Which, if you could specifically
That's, let me see, do I have that referenced here? I guess that's still, I actually don't have it listed where it is there. So I'm not, I don't want to belabor this by jumping around like this. I'm not sure. Maybe we should, I would think maybe we should go through the policies or have another process by which we can ask these specifically rather than jump around and argue about each individual one.
Well, let me start with the handbook then, since you didn't have it. Does anyone wish to speak with respect to the handbook?
I have notes on it, but, in various areas, things that I was concerned about.
I apologize, Mr. Mann, it is the acoustics in this room, but because you are facing away from me, I have a hard time hearing you. So if you can speak a little better into the microphone, that gets projected back to me.
Yes, and this thing has been echoing. In the area of apparent conflicts, is that in the proper section? I think it is.
Which section specifically, please?
B, apparent conflicts in
Yes.
the policy.
That is a quote, again, from the statute, from the state statute.
Right. I have concerns with it. I can take your word that it doesn't have any concerns with it. I think I'm concerned with how apparent conflicts are determined. Ethical standards. I don't have the legal background to really assess these, but I'm uncomfortable with some of the language in this language, the recusal process.
Again, that's actually taken straight from the statute.
But when you say the statute, you're saying Massachusetts?
Absolutely. The Massachusetts state ethics laws, the
Yeah.
ones that we're all required to take the course on a regular basis to update ourselves.
Maybe it's just the fact that.
And just for clarification, all of these have been vetted through council, through town council.
Oh, okay.
Town council has gone through these and has not, where town council had comments, changes have already been made. So,
Okay, well, that's important to know. I didn't realize that. And maybe what part of my discomfort is that some of these issues, which are important issues, recusal, the process that I went through recently for recusal was very interesting and complex and surprising in some ways to me, that I was advised by the Ethics Committee to completely recuse myself and not be in the meeting. And so part of my discomfort is that I'm not used to seeing these in print, and only having to react to them, if somebody says something, and then you address it. So if you're telling me that these issues have all been vetted by our own town council already, and what process should we follow? I don't want to just say yes.
a very legitimate comment. So yes, this is taken straight from the state ethics law. It has been vetted by council. And I guess and I apologize because to some it is jarring to see in terms of what is required of individuals when it comes to some of these ethical standards. As someone who deals with these on a regular basis, I don't see it that way, but that's my familiarity, not everyone else's. So I appreciate and thank you for bringing that up. And I think, but you also raise an important point, which is absent seeing it in writing, for those who are less diligent than yourself, Mr. Mann, who actually went through the process, regardless of not having this book in front of you, there are those who very well may not have done so, or may not do so without being prompted. And I think that, again, as you point out, is why it's important that we have something like this.
I think it's very important. I had the experience on the board of somebody mistaking an organization I belonged to for another organization and claiming in public session that my group was suing them. Now, this attorney should have known better than to make a statement that was incorrect like that, but it put me on the defensive and was very confusing for me. And so I do think it's very important to have these things in writing and a policy we can all lean on and understand. We won't always agree with it, but I do see the importance of it, and I thank you for going through the challenge of doing this.
This has been a labor going on a year now. And there's never a good time to do it. This actually turned out finally to be a good time to do it, although ironically, we were asked to do this. We were asked, where is our policies and procedures manual? We were asked this by the Select Board about 8 months ago. And the Select Board themselves have had their own issues with their own policies and procedures, so they haven't been pressing us. But...
So are there any areas, here's a question, are there any areas that you find tenuous or concerning or potentially problematic?
So
Big and broad.
when it comes to the handbook, no. The handbook itself is relatively straightforward because, again, it does reflect what we're doing now already, or it reflects established town policy, such as the consultation with town council. That was a directive that came through the town manager. With respect to the committees, that's all defined either by the committees, the documents creating the committees or the votes creating the committees, or town charter. Dealing with town staff, again, came through the town manager's request, because that's the policy that the town should be following. Everything else is identified as is coming from state statute, and it is, again, a high-level version of state statute rather than the detailed legal language. And that's why there's actually a specific reference to the statute there in the ethics that says this handbook does not contain all of the requirements, but merely provides an overview as set forth in the documents, most of which came actually from the Attorney General's guidance to municipalities on the state ethics law. So with respect to that, I'm very comfortable.
I have two other areas that I specifically want to address and hear your comments on. One of them is this public communications. In this age of social media and other things, the line here says members and appointees will not utilize their position in any communication media or social media to influence a matter that is or may before them. Must not utilize their position.
Okay, so, well, that's code of conduct, and I'm happy to talk about those.
Yeah, I'm concerned that that is overbroad. And the other...
That was an area that was a challenge, and it's one that you say, do I have an area that I consider to be questioning? That was one. We balanced that out, and one of the reasons that that's there with respect to communication. Now, first, let me start with the fact that both of those statements are actual paraphrases of the ethics training that we received. So I put those in based upon not any particular statutory language, but rather when I last took the ethics training course, which was last year. I take it for both a state position as well as for a municipal position, so I end up taking it pretty much every year. So I always look for commentary and changes on it, so I take both modules every year. And that was one that came up that they talked about specifically, about using a position to influence a matter before them. And the guidance on that is that if you're hearing a matter as an adjudicatory body, you shouldn't be rendering opinions on a matter before it comes to you, because that creates the appearance of bias. And as soon as you have the appearance of bias, you then run into the ethics problems when someone shows up before you and says, you're now biased, you're basing this on information that came before you that I haven't had a chance to actually examine versus what's presented to you. And that was the challenge that was put there. So the reason that it's there is to say, you know, here's the circumstance. That doesn't mean that you can't educate people. It just means you shouldn't be influencing them. You shouldn't be going out there and saying, I'm against this, you should be against this, I'm not going to vote for this. Only because it creates that impression of bias that damages our ability to listen to people and say, you know, gee, you're coming in front of us because we actually are going to listen to you. With respect to, so that's 3.3.1.1 under communications. 3.3.1.2, that actually relates to a concern that's respected, that essentially is just to make sure that people say, I'm speaking on my own behalf, not on behalf of a body, unless I've been authorized to speak on behalf of that body. And that's why, and again, we always have the catch-all, which says, when in doubt, contact somebody and let's figure it out. Again, now we talk about social media, 3.3.2.1. Bring the integrity of their position, the board, or the town into disrepute. The phrase is a legal one, and I understand that that's the case. And it's used in there is actually legal interpretation as to what it is, which is why it's used. It basically goes and says that you can't defame something. And that's what that phrase really relates to. It's defamation more than anything else. You can't essentially turn around and just sort of use the position that you have, again, as an official capacity, to attack in a disreputable manner. Opinion is always, and again, it's nothing shall limit the ability of anyone from exercising their constitutional rights to free speech or expression. And it is a balancing act. And as officials, elected or appointed, we have to stand up for a little bit more in the way of restricting ourselves, because that's the position we've accepted. So I can honestly say that I have edited and re-edited this particular provision over a dozen times. I have run it by counsel, I have run it by ethicists, I have run it by checking other municipalities that have social media and public comment policies. And these were the ones that I felt were the ones that gave the greatest freedom while still at least reminding people of their responsibility. This is not something that we're going to regularly be dealing with, I hope. But to the extent that somebody does something that really challenges, that slanders somebody or defames somebody, or that casts aspersions on a business and interferes with contractual rights, aside from the civil liabilities that are associated with that, we as a board would like to have, I think, some say in the matter. And what we say about it is reflective of what we do and who we are. Now, that doesn't mean in terms of discipline, we're going to be disciplining people all the time, and a lot of this will probably remain confidential, as if something comes in and we go, okay, look, here it is, this is something you said, I understand your value behind it and what you're doing, maybe you want to rephrase it differently, and we move on. And that's done confidentially unless we're going to take some form of disciplinary action. But that was the reason that it was drafted the way it was. I'm, of course, always amenable to suggestions otherwise. But I can tell you that no matter what you do, either you say nothing or you say something like this. And I felt saying nothing reflected poorly on us in the sense that we were, in essence, almost admitting that carte blanche on social media is acceptable, and it really shouldn't be. And particularly in instances where, and I'll point out that the ethics laws actually distinguish between the statements of an elected official and an appointed official. Elected officials have broader latitude. Do I agree with that from the ethics laws? Nope, I don't. I don't like varying standards. But that is what the ethics laws state. We have broader latitude to make statements because as elected officials, we're entitled to certain positions. And we're entitled to actually identify ourselves and our positions. Whereas an appointed official may not utilize their position to identify their positions. That's just the ethics laws. So I wanted to make sure that we did say something about this. So if nothing else, if someone has a question, before they hit that post button, they think twice about it. Maybe they tone down their statement. Maybe they call someone and say, hey, what do you think? But if nothing else, it might reel us back into a little bit more of the way of social discourse. But again, that was an optimistic hope. Mr. Donaldson may be choking to death on that wish, but nonetheless, that was the intent behind it.
Thank you. One specific thing, and at this point I'm confused whether I saw it in the policy handbook or not. I think I did, and it was relative to appointments to committees. Is there language to that effect in the policy handbook?
Yes.
Yes. I am of the personal opinion that there are far too many, and they aren't effective, manners in which boards and committees in this town appoint people, and I think there's built-in prejudice in the way they do it, usually, in that people are either affected by their last name, the time that they applied, where they are on the rolls of candidates, and I am of the opinion that we should have a standardized appointment process where when there's more than one candidate for a position or positions, when there's additional candidates, that we can take means by which we vote on them all at once and therefore do not prejudice the process. Because I've been in the situation, I'm not sure if everyone has, where there are, let's say, 5 candidates for 3 positions or something along those lines, and they're all the same years, and also you're voting on the same thing. And the vote happens in a certain way, an alphabetical way, or a way that they are listed on the sheet, and so the people at the end of that don't even get a vote. And I find that to be less than acceptable. And I'd like to have a very specific process that avoids that, and I think that's possible.
I think that's a very good idea, and I have no problem with working on drafting an appointments process for this board to consider and comment on, and that accomplishes that. At this particular point, that was not part of the handbook that was created. We just, again, made the general I focused on requirements rather than on creating new processes. So that was something that I didn't want to do because I didn't want us to have to spend a lot of time crafting and recrafting as we sat here in a public meeting. But I am more than happy to prepare a draft and working with that idea, because I agree with you. And I have been exactly in that same circumstance as well, early on with respect to appointments, and how people get appointed is definitely questionable, and everybody does it differently. So I think you're right, working on something that in essence allows for every candidate to be given a fair chance rather than have the decision made before a vote ever comes up on their name is a good one. So
I have a draft I'll send you.
Great. Okay, any other discussion on this? Mr. Smith?
Just a point on the social media that we were discussing just now.
Yes.
That seems to be, I'm wondering if that's too narrow, using the term of social media, because there are other methods of communication which should also not make statements that engage in conduct.
Well, it's a general statement, too, that goes with that, but this is specifically with respect to social media. Anyone does it in public and does something that it's a lot more difficult to monitor, and that's the issue. The goal ultimately is not to become a court in which everyone walks in all the time and says, this person said this, and the answer is, well, no, I didn't say that, I said this, and we end up with a debate. Social media, a post is a post, and we'll at least be able to see it. The words will not be in dispute.
No, I'm just thinking about sometimes there are email blasts or other things that, other methods of communication. So if you feel that social media is all media, then I'm fine with that.
I think we can certainly accept that that's, I mean, maybe, I don't know if we want to define social media differently, or if we want to simply say public platforms or communications.
That'd be fine with me.
I'm sorry.
Good.
I think we should also add, media as well. I mean, we do have issues in regards to maybe some things being said in different other media outlets as far as, paper or newspaper or commentary or things like that. I don't know if that's bumps into our First Amendment rights and things like that too. So I do think it is a little broad. There's many other media or communication outlets that that's available for the public.
Well, we do have the phrase public communications right above it. I mean, that's, it again, it addresses the same circumstances. We can, we can certainly change it to say, because again, it's public communications above it.
Social media outlets.
Social media and, we can say it, social media and mass communications,
Yeah.
which would distinguish obviously from an individualized communication. Does that give people a little more?
I'm okay with that.
Can I get a poll of the members? Does that work? Okay,
Yep.
so we can change that to social media. All right, I'm not going to be able to edit on this form. So 3.3.2 should now say social media and mass communications. And then on 3.3.2.1, it will say must not make statements or engage in conduct on social media platforms or in mass communications. So, and again, I appreciate everybody bringing that particular section to the fore, because that was the one that was the greatest challenge in going through this. And one of the challenges in any time creating, whether it's creating statute or policy or practice or handbooks, is trying to keep up with technology. And we are always 2 steps behind. It just changes so rapidly. 5 years ago even, we probably wouldn't have had a social media policy discussion. It wouldn't have been, that was just, Facebook was for people keeping up with their old classmates. And it's morphed. And whether that's, Facebook or Instagram or X or whatever new one will show up tomorrow. So, again, hopefully this is just more of a blinking yellow light to people to pay attention to their communications before and thinking before acting. I don't anticipate this being a major part of our regular practice, and hopefully that will be borne out. But obviously, again, these are policies of this board, and if at any point something isn't working, it's just one phone call away to the chair to say, I'd like to discuss this one particular policy again, or this particular section again, and we will do it.
Mr. Chair, I think we should look at our social media posts at our level in regards to like that 2 a.m. drunk moment that we probably shouldn't say what we're feeling at that time.
I would definitely recommend that. I will say that I do my very best not to be on social media at 2 a.m., and I certainly do my best not to be on social media intoxicated. But nonetheless, I agree.
I have a question, Mr. Chair.
Please.
So after, so we're going to vote whether or not we are in agreement
to adopt these
this?
policies,
And
yes.
then from there, what's the next stages in this process? Or is it going to go to the select board for them to vote on?
Nope.
This is ours.
This is ours, much just like our submission policy is ours, just like our public comment policy is ours. It will go to the town manager, so the town manager has a copy of it to be able to refer people to. And again, it'll be helpful as well, because as we have people being appointed now, we will have something to direct them to say, just so you know, these are your responsibilities too. Please take a look at these. So again, part of this, a lot of this was to provide guidance not to this body, but to other bodies that we appoint to, so that the people we're appointing understand what's expected of them. Because we've had certainly instances where it's been a gray area, or instances in which people have decided to, for lack of a better word, hijack a group by saying, you can't stop me from doing this. There's nothing written that says I can't do this. And that's unfortunate, because our committees are too important. We rely on them too much to have that happen. And when that happens, it takes away from both the experience of serving on a committee, which discourages people from doing so, and obviously we want to do the exact opposite and encourage people to do so. And it takes away from the effectiveness of the committee, which works its way all the way up to the highest levels of our town government, as we rely on those voices to provide us with guidance and thoughts so that we can do our jobs better. Mr. Bennett.
I motion that we accept and adopt the Planning Board Policy Procedures Handbook and the Planning Board Code of Conduct as edited this evening.
Second.
I have a motion and a second. Any further discussion? Seeing none, I'll call for a vote. All in favor? It is unanimous. Great. I will, again, Mr. Mann, if you want to send me your draft, I will be more than happy to do that, and we'll circulate that for further comment from everyone to make sure that we accomplish exactly what you said, which is to try and have the broadest and fairest appointment process we can. And if other people as well have policies or procedures that they think that we should be looking into or adopting, we'll be, we're more than amenable to doing so. I personally believe that the more that is written, the more transparent we are in our behavior and actions, and the more that the public can trust that we're going to do what we're saying we're going to do because it's in writing somewhere. And honestly, it also means that it doesn't change from meeting to meeting, chair to chair, and that's sometimes a problem too that we have, which is different people sit in this chair and do things differently. And lack of consistency is sometimes a real challenge. So hopefully having a policies handbook and code that we all follow going down the line and amend as is appropriate is the way that we will gain or maintain a level of trust within the community.
Accountability, my favorite word.
Absolutely. Does staff want to offer anything on other policies that they're working on right now?
Sure, thank you. Quickly, I will just let you know, we continue to work through a variety of process and permitting improvements, looking to work with other departments as to how we might improve efficiencies and workflow between things. For example, we met with the engineering division today to talk about the review. Again, just trying to see what makes sense, where are we being duplicative, where can we make things more efficient and effective for everybody. So that's just one example. We discussed site plan review with you the last time that we spoke, and we continue to look at what we might propose as a recommendation. The thing about site plan review is that the state laws are silent. So really, it is like every flavor at Baskin-Robbins as you look at how other communities, how they do this. Everybody does it differently, is the moral of the story. So what we are going to come forward with is based on what we've looked at, what we think might make sense for Plymouth, and the direction that we're going in is looking at proposing an administrative site plan review, which would take place at a staff level, making sure that we're still getting public safety, engineering, inspectional services, and planning to be looking at these plans and giving it the scrutiny that it needs without, having to rise to the level of going to a public hearing setting where, there are some thresholds for a size or scale of a project or particular uses where we think it certainly will have that discussion at the planning board level. So we're looking to sort of do a two-tier approach, and we'll be coming forward in the coming weeks for something for you to look at and think about further.
Thank you. And again, as Ms. Lind mentioned earlier, the question was raised about the single-family use that came before us tonight. And again, we've said we don't really have the standard to go ahead and look at single-family, but because it was a post facto complaint, I looked at the state statute, and one of the state statutes is very clear that if there is someone who is aggrieved by a decision relating to an existing zoning bylaw or permit, the planning board has the authority to hear that. So, assuming that there is an aggrievement regardless because somebody has violated our zoning bylaw in doing something in a post facto way and is coming for approval, I felt that that was something that we should take a look at, that as a body, particularly because we do the policy side of planning versus the ZBA, which is a bit more formalistic. And sometimes our recommendations are based not just on the letter of the law, but also its spirit. And I think that, especially when it comes to those types of uses, making sure that we're following the spirit of the law is important. And so that's something that I think we will be looking at, and I will certainly be recommending that we include post facto as being part of site plan review. Anything further from members of the board this evening? Seeing nothing, do I have a motion to adjourn?
Motion to adjourn?
Second?
Second?
All in favor? Thank you all. We are adjourned.